Good afternoon.
Good afternoon.
If you could state your name and spell your last name, please.
My name is Crystal Bowman-Carter. My last name is spelled Bowman-Carter.
What do you do for work?
I'm an attorney.
What kind of attorney are you?
I focus on estate planning and a little bit of business work.
How long have you been doing estate planning?
I have been licensed since 1996 to practice law, but I've been doing estate planning almost exclusively since 2012.
And do you do that practice here locally?
Yes, I have an office in Park City.
Approximately how many estate plans have you drafted in your practice?
1,400, 1,500.
Did you know Eric Richins?
Yes,
How did you know him?
I did some work for him.
What kind of work did you do for him?
I did two projects for him. First, I did a buy-sell agreement for him and his partner for their business, C&E Stonemasonry, and then I did his estate planning.
Did you meet with him in person?
Yes,
How many times?
at least 4.
Okay. Did you know Kouri Richins?
I know of her. I've talked to her on the phone once the day that Eric died.
I want to talk about the first legal project that you did for Eric Richins. You mentioned that was related to his business, C&E Stonemasonry. Is that right?
Correct.
When did you complete this agreement, or when did you work on this project for him?
I was first contacted in June of 2018 by his financial advisor. We got the ball rolling. I gathered information, and then we ended up signing it almost a year later, June 25th, 2019.
Okay. In general, explain to the jury, what is a buy-sell agreement?
A buy-sell agreement is a contract between owners of a company that sets out the terms in advance, what will happen when there is a transfer of a business interest, whether it's by sale or because of an owner's disability or their death.
Are buy-sell agreements, in your experience, are they common?
Yes.
If we could show the witness Exhibit 4-2, please.
Apologize. We'll fix that. Scott, if you unplug for me. You should be able to see that stuff.
I can see it.
Okay.
Do you recognize this document?
Yes.
And what is it?
It's the C&E Stonemasonry LLC buy-sell agreement that I prepared.
Okay. I'm going to move to admit 4-2.
Ms. Lewis, Mr. Ramos. Oh,
No
Ms.
objection, no objection, Your Honor.
Okay. States 4-2 is admitted.
If we could publish this and move to Article 3, please. What's contained in Article 3 of this agreement?
Article 3 provides what happens if one of the partners or owners of the company were to die.
And essentially, what does it say in non-lawyer speak?
Well, the mandatory cross-purchase agreement provides that if one of the partners dies, either Eric or Cody, then the decedent, the person who has died, their estate has to purchase the business interest from the surviving partner using life insurance.
And is that the life insurance was what was used in this buy-sell agreement?
Yeah, so this buy-sell agreement used 4 different $1 million life insurance policies. Each of Cody and Eric had 2 $1 million policies on the life of the other, and if one of them were to die, they had to use that money to purchase the interest in C&E Stonemasonry from the estate, so that the survivor could continue to control the company and run the company.
Is that a pretty common
Yes.
thing in buy-sell agreements?
Excuse me.
That's
Yes, it
great.
is.
I want to move now to talk about the second project that you did for Eric Richins. You mentioned that was a estate planning
Yes.
project. Was that did that take place in October of 2020?
Yes, he came to see me. He called my office on October 5th and came to see me on October 13th, 2020.
And so what was the purpose of that meeting?
It was to update his estate plan and revoke a prior power of attorney that had been abused.
When we're talking about an estate plan, what are the main documents that come out of an estate plan?
So the basic estate plan that everyone needs is a will, a durable power of attorney, and a health care directive. And sometimes, most of the time in my practice, you also need a trust to avoid probate and to protect the beneficiaries of your estate plan from themselves or from others.
Okay. In preparation for that meeting with Eric Richins, did he fill out some paperwork before and during that appointment?
Yes, I have all of my clients fill out an intake worksheet, gather information about their priorities and their assets. He partially filled it out, brought it in with him to our meeting, and then we filled out the rest together as we discussed what needed to be done.
And these intake worksheets, how is that something that your firm uses with every client, or how does that work?
Yeah, either my office manager or my receptionist sends it out to everyone. It's something I can't really function without.
Okay. If we could show the witness 4-9, please. And go ahead and scroll through it so she can see the whole thing. Do you recognize this?
Yes.
And what is this?
That's my estate planning worksheet filled out by partially by Eric and partially by me.
Okay, I'm going to move to admit 4-9.
No objection.
4-9 is admitted.
Now, if you could take that binder in front of you and turn to tab 9. Is that the same exhibit that we're looking at in 4-9?
No.
Okay. Which one is that?
You're having me look at the healthcare directive.
Oh, I see. We'll come back to that one. I had it labeled wrong. Before creating Eric Richins' estate plan, did you review a premarital agreement?
I reviewed it the day before he signed his estate plan.
Okay. If we could, 4-1 is the premarital agreement. That's already been admitted. If we could publish that, please, and go to section 1. And paragraph 5. So this is the document, the premarital agreement that you reviewed. What
Yes.
does paragraph 1, section 5, again, the non-lawyer version, what does this say?
So what it says is that C&E Stonemasonry would remain Eric's separate property to dispose of as he wished during his life after his marriage to Kouri Richins.
And if we could go to section 2, please. What does this section of the premarital agreement deal with?
Again, it deals with Eric's separate property, that C&E Stonemasonry will remain his sole and separate property, even if they commingle marital funds, except that if he were to die, then his interest in the company would pass to his wife, which is Kouri in this document.
Okay. And if we could go to section 3, please. And how about this section? What does this?
So that section addresses primarily Kouri's rights in C&E property that she might have under the law at Eric's death. Can I elaborate on
Sure.
that? Okay. So if you don't have a premarital agreement, then you have rights in your spouse's estate. And when you're a nuclear family with no children from a prior marriage as they were, that means that if your spouse dies, you are entitled to at least 1/3 of the augmented estate. In other words, everything that passes to anyone as a result of your spouse's death. And this paragraph, the section 3, paragraph 1, says that Kouri is giving up her right to that 1/3 as it concerns C&E masonry, stone masonry.
So I want to turn your attention now to that actual meeting that you had with Eric Richins in October of 2020. What was he there to accomplish? Why was he in your office?
He was referred to me, I'm not sure if it was from Christina Miller or Brian Freckleton, referred back to me. I had worked with him again to update his estate planning based on some recent financial malfeasance and some current concerns that he had for his sons, that if something were to happen to him, they wouldn't receive or be cared for financially with his assets.
When meeting with Eric Richins, was there something unique to you or something that you did for the first time in preparing his estate plan?
Yeah, there were a few things.
What were those?
So, one, he didn't want us to communicate with him by email. That happened a little bit later, but because he was worried that Kouri would be reading his emails. Two, he wanted to leave everything to his kids if possible. And at the beginning of the representation, I hadn't seen the premarital agreement. He wasn't sure if it existed, but eventually, communicating through his sister, as he instructed, we received the premarital agreement and saw that it unfortunately did not address all of the property. It only addressed C&E stonemasonry. So for that reason, for the first time ever in my career, I had to draft around that augmented share. So we provided at a minimum that there would be a share created for Kouri consisting of one third, the amount she would be entitled to, and the rest passed directly to his kids. That also applied to tangible personal property. He said that all his tangible personal property, things you can touch and feel, like your furniture, your jewelry, your collections, would pass directly to his sons, who were all very young at the time, and that's unusual. It usually passes directly to the spouse. I think there was one other thing, but I'll come to it.
If it comes to you, let me know.
Mm-hmm.
So I want to turn your attention now to those estate planning documents that you referenced that you prepare when doing estate plans for most people. And for Eric Richins, did you prepare a living will?
A living will, a healthcare directive?
Yes.
Yes.
And did you also prepare a trust?
Yes.
Okay. I want you to take a look at Exhibit 4-11. We'll put it up on the screen for you. And if you could scroll through it, Scott. Do you recognize this?
Yes, that's the will I prepared for Eric Richins.
And then if we could show the witness 4-12. Do you recognize 4-12?
Yes, that's the trust I prepared for Eric Richins.
Now, in the book you have in front of you, I'm going to ask you to turn to tab K, or to tab 6. Is that the will that we just saw in the same exhibit?
Yes.
And there's a signature as a part of that document. Is that correct?
Yes.
And who is that document signed by?
The document was signed by Eric Richins on page 8, and his initials appear on every single page of the document.
And you notarized that document, right?
I witnessed and notarized the document.
If you could turn to tab 10 in that binder. Is that the trust document that we just saw?
Yes, it is.
And is that document also signed?
Yes, it is signed. It's signed by Eric Richins, and I notarized it.
Okay, and that means you saw him sign it in front of you, right?
Yes, you have to. If you're a notary, you're required to be there in person to witness somebody signing something before you can attest to their signature.
And then also on tab 9, you told us that was the healthcare directive. Is that right?
Yes.
And is that document signed?
Yes, it is.
And similarly, did you see Eric Richins sign that?
Yes, I did.
Okay. I'm going to move to admit 4-11 and 4-12.
No objection.
4-11 and 4-12 are admitted.
If we could put up 4-11, please, and publish to the jury.
4-11's up.
And so this is the will you described that you prepared for Eric Richins. Is that correct?
Correct.
I want to go to section 7.03, please. What does this section provide for?
That's the section where Eric expressed his intentions for the disposition of his remains. He wanted to be buried upon his death.
Now, talk generally about this document and what kind of legal implications, this document has.
So in the case of a trust-based estate plan, which is what we prepared for Eric, the will is not usually as important as the trust. All of his directions for what he wanted to happen to his assets and the protections he wanted to put in place for his loved ones were contained in the trust. You still have to have a will. It's called a pour-over will. It says that if I leave anything out of my trust, if I forget to make a beneficiary designation when I die, give it to my trust to be controlled by the terms of my trust. And then I always include either burial, cremation instructions if somebody has a preference. Sometimes people don't have a preference, then I don't say anything. Anything that's governed by a will has to go through a process called probate. That's the court-supervised process of administering an estate, the non-trust assets. So when you draft a trust-based estate plan, or when you execute a trust-based estate plan, the idea is you're avoiding probate. You don't need to use the will. It never has to go through probate. The will is just a backup document.
So now if we could put up 4-12, please, for the witness. And we can publish this as well. So talk about, in general, how a trust works.
Okay, so a trust is a contract between, and I'm going to use Eric specifically because this one was prepared for him. It's a contract between the party who drafts it, the party who's going to benefit from it, and the party who's going to administer it. So initially, a trust is a contract between you, me, myself, and I. Eric was the grantor. He created the rules for the trust. Eric was the trustee. That means he was the manager of the trust, of all the assets that were contained in the trust, and had to follow the rules that he set. And then Eric initially was the beneficiary until such time as he became, until he died. He was the trustee until such time he became permanently incapacitated or died, and then somebody else would manage those trust assets. It's like a box that you have rules for. You put the assets in, and those rules control all of the assets in the box.
So you mentioned that a trust, the trustee was Eric while he was alive,
Yes.
and then he chose someone else to be a trustee in the event of his death. Is that correct?
He did. That would be at Article 3.
Okay. Who did Eric choose as his trustee?
He chose his sister. Well, he chose a couple of successors. His sister, Katie Richins-Benson. And then I want to see who he chose as this. And then I'm looking at the will still.
That's okay. You don't have to look at it. If you don't remember, that's okay.
No, it was Katie that he chose as his first successor trustee, and I believe it was Clint as the second.
What is a trustee?
The trustee is the person who has legal title to the assets in the trust and is charged with managing those assets for the benefit of the beneficiaries of the trust in the way that the trust says.
In your experience, was it unusual for someone who was married to not choose their spouse as a trustee?
Yes.
What effect did the trust have on Eric Richins' property?
While he was alive, he could still do anything he wanted with the trust assets because it was a revocable trust. But the trust owned his property in that little box. And the effect was that when he died, it became irrevocable, and those assets had to be administered according to the terms of the trust that he set.
Scott, if we could go to Article 8.01 of the trust.
Excuse me.
Describe for the jury, in layman's terms, what this section of the trust means as it pertains to Kouri Richins.
Okay. Might be a little wordy here. So on
Do your
Eric's,
best.
on Eric's death, this trust became irrevocable and sub-trusts were created. A trust for Kouri called the Q-tip trust that you see here at Article 8, and then the next trust is the Descendants Trust that was for the benefit of the kids. Because it was a Q-tip trust, the law requires that all of the income generated by the assets held in that share must be distributed to Kouri during her lifetime.
So did the trust provide for Kouri Richins' household expenses?
Not specifically, but there's another, the guidelines for distribution also provide that she's entitled to also access the principal through the trustee for her health, education, maintenance, and support. So yes, she was provided for, just not household expenses specifically.
And you mentioned that a trust is like a box that someone can put their assets into. What were some of the assets or the assets that went into Eric Richins' trust?
So the easiest thing we did was he signed an assignment of tangible personal property. So things that don't get titled anywhere, like your furniture, your jewelry, those collections. By signing that document, that transferred those things to the trust. I prepared a deed for him for the house that he owned in his name, and we transferred that asset to his trust. I think the house was on Willow Court. And then I prepared an assignment of interest in C&E Masonry that he signed later on in February. After the trust was built, then we could put the things in it, and he signed that in February of 2021. Put that in the trust, and also another LLC interest.
Scott, if we could go back to just the first page of 4-12, please. Even the title page for, yeah. So that document has a date on it. What's the significance of that date?
That's the date that Eric signed the trust, and for titling purposes, we include the date in the name of the trust.
And so, for all intents and purposes, that's the effective date. That's when it becomes legally in effect.
That's when it becomes legally binding, yes.
If we could show the witness 4-14, please.
What? Scott, go ahead.
And if you could scroll through it so the witness can see the document. Do you recognize this document?
I do.
Did you prepare it as part of Eric Richins' estate plan?
Yes, it's the power of attorney that I prepared for him.
I'll move to admit 4-14.
No objection.
4-14 is admitted.
If you could explain, you mentioned that this is a durable power of attorney. What is a power of attorney?
It's a document that nominates an agent, somebody that you choose, to manage your property if you become incapacitated, or sometimes immediately.
And what effect did Eric Richins' power of attorney have on his estate plan, or who did he choose as his power of attorney?
I'm sure he chose Katie Richins-Benson.
Okay, if we could show the witness, I don't want you to look at anything just yet. If we could show the witness 4-13, please. Do you recognize this document?
Yes.
What is it?
I'm scrolling through it. It's a draft revocation of a prior durable power of attorney.
Is this also a document that you prepared for Eric Richins?
Yes.
I'm going to move to admit 4-13.
No objection.
4-13 is admitted.
If we could publish 4-13 to the jury, please. So this was a document that you drafted as part of Eric Richins' estate plan, is that right?
Yes, I drafted it, and then you can see that there's the prior durable power of attorney is attached as an exhibit. I didn't draft the prior power of attorney.
Certainly. Was this document ever recorded?
This version of the revocation of durable power of attorney was never signed or recorded.
Do you know why?
Eric was concerned about the repercussions he would face if he told Kouri.
Object to hearsay, Your Honor.
That was my impression.
Pause. Jury, I appreciate your patience. You cannot consider what Eric Richins said to Ms. Bowman-Carter.
And so I'm not sure if your answer was heard by the jury. I won't ask you why, but was this document ever recorded?
No, this document was never recorded.
Okay. Now, you mentioned earlier that you were communicating with Eric Richins' brother-in-law, I believe.
I had communications with Eric Richins' brother-in-law, yes.
And you were instructed to only communicate with the brother-in-law, is that right?
I was instructed to communicate with his sister, and I was given I believe it was a shared email account.
Okay.
And they both responded there.
Was that unusual in your practice?
It was the first time anyone had asked me to do that, so yes.
Okay. I now want to turn your attention to the week that Eric Richins died. Did there come a time when you learned that Eric Richins had died?
Yes, I learned that day that he had died, March 4th, 2022.
And is that when you became aware of it, or was that a day later?
I believe I learned the day that it happened.
And how did you learn about Eric Richins' death?
Clint Benson called me and told me that he had died.
And did you also receive a call from a sheriff's deputy that day?
Yet later that day, I received a phone call from somebody who identified themselves as the sheriff's deputy, and who asked me to talk to Kouri.
And did you talk to Kouri on the phone that day?
Yes.
What did you tell her?
Apparently, she was upset about the house, and I was asked to explain that there was an estate plan in place and that the house belonged to the trust, and that's what I told her.
When you were explaining to Kouri Richins that the house belonged in the trust, how did she react?
Oh, not positively. She was livid. She was upset, and she said, "What is wrong with you people?" and handed the phone back to the officer, I believe.
When having this conversation with Kouri Richins, was it your impression that she was unaware of the estate plan?
Object to speculation, Your Honor.
I'll lay a little foundation.
What could you tell from your conversation with Kouri Richins about her knowledge regarding what would happen with the house?
She told me that the house she told me the house belonged to her. She thought the house was hers, and obviously, if she thought that, then she was unaware of the estate plan and that the trust owned the house.
When were you contacted by an attorney representing Kouri Richins?
Yeah, a bankruptcy attorney reached out to me.
Objection, Your Honor. Can we approach?
Sure.
So you mentioned that you received an email from an attorney representing Kouri Richins. Is that right?
I received an email on March 8th from an attorney that said he represented Kouri Richins.
Okay. What, and so, sorry, I missed the date that you said. He contacted you on March 8th, is
March
that right?
8th, 2022.
What was the general nature of that email?
Just to tell me that he represented her and to ask that we give her time to grieve, don't act too quickly, so that she could attend to services, and I believe that was it.
And so he was contacting you in reference to the estate plan, is that right?
Possibly. I'd have to look at the email, but I don't even know if he referenced the estate plan.
He was talking about the house that was in the estate plan, is that right?
Yes.
Did you, after that email exchange on March 8th, did you provide any documents to Mr. Nate?
Yeah, it was Attorney Nate, and I did provide him with a full copy of the estate plan. I pointed out several things, including that the will called for burial and asked.
Yeah, go ahead. You can finish.
And asked and because I had become aware that Kouri was seeking to have his body cremated, so I wanted to make
Judge should be hearsay and non-responsive.
Well, taking him in reverse order, overruled, and it's unclear, so I'll sustain it, lay some more foundation.
Sure. So one of the documents that you provided to Mr. Nate was the will. Is that correct?
That's correct.
And one of the reasons you provided him the will was so that he was aware of Eric Richins' wishes as it concerned his burial.
Yes.
Did you open probate on Eric Richins' estate?
Yes.
When did that happen?
March 14th
Of 2022?
Only 10 days after Eric's death.
In your experience, is that, first, I'll ask two questions about opening probate. Was that a typical time frame for those events to happen?
No, that wasn't a typical time frame.
What do you mean by that?
Well, a couple of reasons. Usually people need to get through the services and grieve a little bit. If the property is secure, there's no reason to open probate right away. But in this case, Eric had a fully funded trust. I never would have opened probate if we were just administering the trust. That's the whole reason you have a trust, is to avoid having to go to court, make everything public.
And so when you're saying the time frame was not typical, it was quicker than usual. Is that fair?
Yes, it was much quicker than usual. And with a trust, I just wouldn't have opened probate. If at all, I would have opened probate a year after the death, after creditors' claims had been cut off.
And so you opened probate quickly because there was some urgency, in your view?
Yes. Eric had... Can I explain why?
Please lay some foundation for how she knows whatever she's about to say.
Well, sure. Did you... Can we approach? I don't want.
Ms. Shervanack, please proceed.
Without telling us any specific statements or what anybody said, why did you open probate so quickly?
I needed to get the nominated personal representative in place so that she, Katie Richins-Benson, would have the ability to manage the probate estate and make sure that Eric's wishes, as expressed in his will, were followed.
Thank you. And I neglected to check. Have I admitted Exhibit 4-14? I know I talked about it with this witness.
We've checked
Did we?
it. Oh, I'm sorry, wrong one. No, it wasn't there, Your Honor, without
Okay,
objection.
I just didn't have a note there, so I wanted to make sure I admitted it.
Ms. Nestor is correct. It's been admitted without objection.
Those are on my...
Ms. Nestor, please.
Thank you, Your Honor.
Good afternoon, Ms. Bowman-Carter.
Good afternoon.
My name is Kathy Nestor. I'm one of the attorneys representing Kouri Richins today. All right, so I want to talk with you about the revocation document that you talked about with Ms. Shervanack. Could we please bring up 4-13? It's been admitted, Your Honor.
One moment.
Okay.
can see that, Ms. Bowman-Carter?
I can see it.
Okay, go
All
ahead,
right.
Ms. Nestor.
And can we scroll down to the beginning of, or actually the very bottom of it, the date of the original one that they were contemplating revoking? And just to refresh, you mentioned on direct, this was actually never done. You actually never did revoke this power of attorney, correct?
Incorrect.
Okay, I'm sorry, I may have misunderstood you. I thought you said that you all ended up not revoking it.
No, I said we didn't sign this document.
You didn't sign it. So I know what you're getting at. So in your durable power of attorney, you mentioned revoking all previous attorney powers of attorney, correct?
That's not what I was getting at, but that's correct.
Okay. But this particular document never got signed or filed or anything?
No, another revocation got signed apart from the durable power of attorney that he signed.
Okay. And the date on this document that you all were contemplating revoking but didn't ever sign this document was May the 8th of 2013. Is that right?
That's what this document says.
So this is the power of attorney that all the parties were contemplating, saying this doesn't, you can't use this anymore, right? From now on.
This power of attorney was revoked, yes.
I'm trying to not use lawyer words. I'm trying to use like normal words, just so to make sure we're clear. So revoke just means we can't use it anymore, right?
Right. It's
Okay.
taken back. It's null and void.
Perfect. Thank you. That's what I was getting at. So to your understanding, this power of attorney had not, there'd been no prior revocation filed on this power of attorney. In other words, it had been in place since May of 2013.
Right, but circumstances changed and he wanted to revoke it.
Sure. Anybody can revoke a power of attorney anytime they want, right?
Correct.
But he hadn't done that up until now, till he saw you in 2020.
That is my understanding. He may have gone to someone else, but this is the first time I learned of it.
Okay, thank you. You can take that down. Do you remember being interviewed by law enforcement within about a year or so after Eric passed?
Yes.
Okay. And when you were interviewed by law enforcement, do you recall telling them that it stuck out in your mind how kind Eric was about Kouri using that power of attorney in a way that he didn't like, right? Do you remember that?
Objection, Your Honor. Calls for hearsay.
That's her own statement, Your Honor.
Which is why it's a problem that it's coming in through you.
Well, I'll lay a little more foundation.
Sustain.
Was it your understanding that the goal of revoking this power of attorney that had existed before was that Kouri couldn't be trusted to utilize it well?
Yes.
And why couldn't she be trusted to utilize it well?
Because she had stolen she had misused it to take $250,000 out in his name, and he did not like that.
Totally fair. And isn't it also true that it was your understanding that Kouri's business acumen or business skills were less than fantastic because she was young and inexperienced?
I have no personal knowledge about Kouri's business acumen and skills.
Did you make that statement in your prior interview to the police?
I repeated what Eric told me about her business acumen and skills.
Okay, and what was your understanding of that?
I had no understanding of her business acumen and skills.
But what'd you tell the police?
I told the police what Eric told me,
Which was what?
that she was misusing the power of attorney, that I wanted to include stronger language in his estate plan, more protective. I was surprised that he was willing to. He said that she's the mother of my children. I know that she made mistakes. She needs some more experience. for now, I'm going to do what I'm doing.
Great, thank you. Was there also, when you decided to add the house to the trust, did you do any investigation into whether Mrs. Richins had been contributing to the mortgage throughout the marriage?
I did not, wasn't relevant.
Okay. When you said that all of Mr. Richins' personal property was poured into the trust, did you do any investigation into whose funds purchased all that personal property?
It wouldn't matter if it was gifts, but no, I didn't.
So, for example, the furniture in the living room, do you know whether Kouri purchased it with her money or Eric purchased it with his money or it was joint money? Do you even know?
No, how could I know?
Okay. And you made no effort to find out?
The assignment that Eric signed transferred his personal property.
Right.
If
So you took his word for what was his personal property as opposed to what was hers?
I didn't have to take his word, he was only transferring what was his personal property.
Okay. And did he give you an inventory of what that personal property was?
No.
Okay, so you didn't know.
Well, there's a worksheet and he listed some things, like his guns, but he didn't prepare a very specific inventory. I just prepared an assignment that he signed, transferring all of his personal property to his trust, as is customary.
So that would ultimately be decided probably by the trustee, whether she was trying to divvy up the proceedings as required under the trust, whether that couch was bought by Kouri or that couch was bought by Eric.
That's likely.
And you didn't give any guidance to that in the trust, the document itself.
What are you asking?
Was it listed in the trust, each and every item that was considered Eric's personal property?
No, it was just all of my household furnishings in effect.
Okay. You said all the household furnishings were his personal property?
No, I said all of my household furnishings and effects, meaning all of Eric's household furnishings and effects.
Gotcha. Okay. You also, in the trust documents that you drafted, it's pretty common that you do what's something called a statement of intent, right?
No, it's not common at all.
So it was unusual that you did that.
Yes.
Katie, can you pull up 412, page 1-2, section 103? This is in, Your Honor. If we could publish.
Okay. There you go.
And can you blow up the statement of my intent? So this is the part you said is unusual for you to do.
I mean, it's not unusual to, trusts will have them, but for me, I typically don't include one unless there's a reason.
So did you have a reason for including this?
Yes.
Okay. And I assume it was something the client wanted?
Yes.
Okay. And the language in here states that the intent of the trust is to provide for both Mrs. Richins and the children throughout their lifetime, right?
Right, we revised that the day of signing.
Great. You can take that down. Did there come a time, you mentioned that it was your understanding that Mr. Richins did not want you to communicate with him directly, right?
By email directly.
Right. And is that because he and his wife shared an email account?
I don't know. It was E. Richins, I think. I don't think they shared an email account. I don't know.
Okay. So you just don't know.
It was not because they shared an email. What he told me was not because they shared an email account. It was because she snooped in his email.
Okay.
That's what
So
he
she
told
had
me.
access to his email at least.
I don't know. That's what he told me.
Okay. And were you aware at that time that he was consulting a divorce attorney?
Yes.
All right. So when you previously said it's very unusual to not put your spouse as a trustee, if the individual was considering divorce, that wouldn't be unusual to put someone other than your spouse, would it?
No, that wouldn't be unusual.
Okay. And was there a time where you accidentally did notify Kouri of something?
Yes.
Explain that, please.
Kouri Richins, Kay Richins, and Katie Richins-Benson. Very similar names.
Sure.
After I spoke to Kouri on the phone, I sent an email to Katie, I thought, which actually got sent to Kouri.
Okay. And in that email, do you remember the date of that?
It was probably March 4th, the same day that I talked to, it may have been March 5th, but I think it was March 4th, 2022.
Right.
The same day I talked to Kouri.
And just talking about that conversation you had with Kouri, so this is less than 48 hours after her husband has died, right? Give or take.
Yes.
And your purpose of your conversation was at Katie Richins' request?
No, it was the police's request.
Okay. And what you told her before she got very, very upset was the house that you live in is not yours.
I told her that she did not have title to the house.
Okay. So basically you're telling a new widow that she's also about to be homeless?
No, not at all. That's ridiculous.
Over.
Did you tell her there was any other homes provided for her by Eric waiting on her somewhere?
No, but I told her that he had that she would not be kicked out of the house, that she could continue to live there, and that he had provided for her in his estate plan.
Okay. And if I understand your previous testimony correctly, you never actually asked her, what did you know about all this before he passed, did you?
No.
Right. So you don't know whether Kouri Richins knew there was a trust before he died?
It was apparent that she didn't.
I'm sorry, do you have any personal knowledge as to whether Kouri Richins knew before his death that there was a trust in place?
No, I have no personal knowledge of that.
Okay. I want to talk about the intake form that Ms. Shervinack went over with you. If we could please pull up 4-9. It's also been admitted, Your Honor. And if we could scroll forward till we get to the page where he lists his assets. Keep going. Keep going. Keep going. Keep going. There. Your Honor, can we, can we blow this up just a little bit, that top half, so we can see it? All right, so this is the section where you ask the client to list, I guess, what they're worth, right?
Yeah, that is a summary of the assets listed on previous pages.
Okay. And Mr. Richins, it looks like, wasn't sure about stocks and bonds, life insurance, and retirement, and directed you to ask Freckleton, right?
That's pretty common. Clients don't want to fill everything out,
Yeah.
and he knew Brian Freckleton had worked with me before on the buy-sell agreement. He said, talk to him about that stuff.
But he does say that they had $100,000 in bank and savings accounts at the time,
That's what this document says.
and $65,000 in vehicles at the time.
Well, you said they. He says he.
Okay. 65,000 in vehicles
That's what this document says.
and 30,000 in furniture and personal items
That's what this document says.
and $1 million in real property.
Yes, that's what this document says.
And it looks like he's valuing his business, at least his share of the business, at about $3 million. All
That's what this document says.
right. And that he had some anticipated inheritance, not a ton, but some. Right?
That's what this document says.
So his best estimate of his net worth was about $4.6 million if you don't include stocks and bonds, life insurance, and retirement plans.
That's what this document says.
So as long as he's alive, I believe you said that he could do whatever he wanted with any of the money that was assigned into the trust, right?
Yes.
Because it's revocable.
Yes.
So as long as he's alive, he can share any of this money that he wants with his wife.
He can make gifts to whoever he wants.
And he can share 100%, 0.5%, whatever he wants as far as his monthly income, right? With his wife.
I'm not sure what.
So nothing about a revocable trust prohibits him from, if he's making $33,000 a month, giving his wife half of that or more.
He can do whatever he wants with his property.
And if he lived to be 70 he could give her as much as he wanted until he's 70, right? No matter what the trust says.
Like I said, he can do whatever he wants with his property.
But the minute he dies, Katie Richins-Benson decides how much money, if any, Kouri Richins gets, right?
The successor trustee, who happens to be Katie Richins-Benson, has to follow the rules of the trust set by the grantor, who is Eric. So no, Katie can't do whatever she wants with the money. She has to follow the rules of the trust.
Totally fair, and you're
that
right.
were set by Eric Richins.
But she's the one who will decide from the moment he dies forward whether, if, how much Kouri gets any of Eric's money.
Yes, that's what Eric wanted.
And if, hypothetically, Kouri Richins knew about the existence of the trust, she would know that as well.
I don't know what Kouri would know from reading the trust.
But that's what the trust says in plain black and white in the paper, right?
Can you repeat what you're saying the trust says?
Yep, that
Pause for a moment. Go ahead, Ms. Sherman.
Your Honor, calls for speculation. She does that. She can't answer as to what Kouri would know.
Sustained.
the trust, if someone had a copy of it, lays clearly out what we've just discussed, that as long as Eric's alive, he can do whatever he wants with his money. Once he dies, it's up to Katie.
Like I said already, it's not completely up to Katie. She's the trustee of the trust. She has legal title to those assets, and she has to follow the rules of the trust, which say she has to give Kouri a certain income, that Kouri can come to her and ask for distributions of principal for health, education, maintenance, and support. This trust was primarily to protect the boys.
Did you ever advise Katie in her role as trustee, since you drafted the trust papers? Did you ever give her any explanation about her duties or talk to her about what she could and couldn't do?
That's attorney-client privilege.
She's your client?
She was my client after Eric's death for a period of time.
As of when was she your client?
As of Eric's death?
She's still your client?
No.
How much have you been paid by Katie Richins-Benson?
I waived my fees.
You waived your fees. So you're her lawyer for free?
I'm not her lawyer anymore.
Okay. How long were you her lawyer?
I was her lawyer through, I think I formally withdrew in June. She needed a firm that had more capacity than I had with just me.
When you opened the probate, were you then responsible for any pleadings that came in and out of the probate matter? Would
do
you
you
have
mean?
gotten copies of them?
I opened probate. I drafted the probate pleadings.
Right. So if, for example, Kouri had asked Katie after Eric's death, can you please pay the mortgage for the next year out of the trust? That request would have gone through the probate, right?
No.
Okay, so how would it have gone?
Katie was the trustee of the trust. That is not subject to probate.
Okay. So do you have any personal knowledge whether whether Kouri Richins ever asked Katie Richins for any distributions? Do you have any personal knowledge?
Pause for 1 second. Your objection, Ms. Sherman.
Calls for hearsay. Corey's statements to Katie.
Yeah, only if it's, so would you exclude Kouri's statements, but re-ask your question?
Without saying anything Kouri ever said, which, by the way, it sounds like you didn't communicate with Kouri anyway, but were you aware in your role as the person assisting the trustee whether any request for any money ever came to that trust in the year after Eric died from Kouri Richins?
I need you to be more specific to make sure you're not seeking hearsay. Break it down.
In writing or legally or formal request to the trustee?
What in writing or legally?
Requests for distributions to Kouri, to her boys, anything from the trust?
I have no personal knowledge of that.
Okay. You also mentioned that you were talking to a lawyer that you knew to be a bankruptcy lawyer, right? When he called you about Kouri shortly after the death?
I was surprised at how quickly he got in touch with me, and some of his claims about the way the property was titled, so I looked him up to see if he even knew anything about estate planning.
But you're certainly not telling this jury that he was representing Kouri in a bankruptcy, right?
No, I
Okay.
just was curious, so I looked him up to see that it made more sense when I found out he was a bankruptcy attorney.
But he wasn't calling you about a bankruptcy matter. He was calling you about, please give Kouri some time to grieve before Anything goes on with the house?
He never called me. I mean, he called me later, but in the email, he asked, please don't move forward on the probate until she's had time to grieve.
Okay.
He
And you
didn't
gave-
mention a bankruptcy.
All right. I just want to make sure that the jury doesn't think there was a bankruptcy matter going on. There wasn't, to your knowledge, correct?
I have no idea.
Okay. And then you also said that you told this lawyer that Eric wished to be buried. Is that right?
That's what his will said, and I did say that in a subsequent email.
And in fact, Eric was buried, correct?
I believe so.
Right. Did you go to the funeral?
No, I didn't.
Are you still close with his sister?
No, I've never been close with his sister.
Okay, well, you were her lawyer.
That doesn't mean I'm close to her.
Oh.
It was a professional relationship.
Okay. How often did you talk to her when you were her lawyer?
As needed.
Daily, weekly, monthly?
I think it was daily at first.
Okay. Court's indulgence for just 1 minute, Your Honor.
Of course.
Thank you, ma'am. Your Honor, we send the witness back to the state.
Anything further, Ms. Sherbanek?
No, Your Honor.
May we release Ms. Bowman-Carter?
Yes, Your Honor.
You're free to go. Take care. Counsel.
Thank you.